Going to hear entirely from two speakers, Will McDowell and Louisa Rataka, who, as you're going to hear, are extremely well positioned to explore for us this topic, which is ethical dilemmas for tribunal counsel and how to resolve them. To my immediate left is Will McDowell, who is a partner with Lenser Slate in Toronto. Will has a very diverse practice, primarily litigation, but has been involved fairly extensively in the administrative tribunal world, both through his work in professional discipline as a bencher who hears professional discipline cases, and also because of his work on the Mississauga Judicial Inquiry, where he was counsel. So both he and, as you will hear, Louisa have had the experience of acting as counsel to adjudicators in an adjudicative setting, and will be able to share some of that experience with us. Louisa Rataka practices as well in Toronto at Stockwoods, where she too has a fairly wide-ranging practice in litigation. But again, her involvements over the years have really placed her well to be addressing a conference around administrative law, both because she has been counsel in a major coroner's inquest, but also involved in 3 different judicial inquiries, including the Gouge Inquiry, the SARS Review, and along with Will, the Mississauga Judicial Inquiry. She also acts as independent legal counsel for a wide range of regulatory bodies, professional regulatory bodies, including the College of Nurses. So both Will and Louisa have, as I say, acted as counsel in settings where I think some of the dilemmas they're going to discuss today can be evident. And so without further ado, I'm going to turn it over to them. They're going to present. They have a PowerPoint to assist, and I will follow up with some questions and then throw it open to questions from all of you.
Great. So I'll start off. Works. Okay. So when Julie, Will, and I were talking about what we thought some of the major ethical dilemmas were for, I'm being told to move over. Okay. Sorry about that. I didn't realize we were being filmed. We immediately agreed that one of the potential areas of concern for counsel is really the role that counsel play in the deliberation and or reasons writing process in tribunals. And so we thought that we would take a little time in the first part of the presentation to talk about what the cases say about appropriate roles for counsel in deliberations and reasons writing. And then we were going to finish off the presentation with a few real-life examples of cases to consider where we think some very interesting ethical issues were raised. And so that's how we'll split the time. And so just some general points here. Certainly, when considering what role counsel should take, if any, in the deliberations and reason writing process, there's some really basic general things we think to keep in mind. And these are maxims from court cases that none of this would be new to anyone in the room. But first, those who hear the case should decide the case. So it really is important for the decision makers, for the hearings officers, to be the decision makers, and that really goes without saying. The second kind of general point is the parties really have the right to know who's really making the decision, and so again, it really should be the hearings officer, the person who is receiving submissions or hearing evidence from the parties. That should be the person or people making the decision. And also something to consider, and my familiarity certainly is more in the Ontario regime, and I'm sure this is similar in federal and other regimes as well, but there are even statutory rules in place that say that to ensure that the person or tribunal hearing the case decides the case. Sorry. Okay, so the first role counsel could play, obviously, is a counsel appearing before the tribunal for one side or the other. And this is the easy one, I think. Simply put, a counsel that appears for the tribunal on one side or the other, appears in front of a tribunal for one side or the other has no role, should have no role in the tribunal's decision-making process or reasons-writing process. If asked to do so, counsel should not take part in the deliberations and reasons writing. Again, that may seem obvious, but we certainly were, we found an older case in any event. Oh, the case name is on this slide. It's from the Ontario Racing Commission, which is somewhere I do work now, but I certainly wasn't doing work there in 1979. And it's a decision of Sawyer and the Ontario Racing Commission. And in that case, in fact, what happened there was the prosecutor, so the person who was appearing in front of the commission on specific charges, was called into the deliberation room after the fact, told of the commission's decision, and then asked to draft reasons, and did so. And not surprisingly, the Court of Appeal in Ontario said that's not an appropriate role for counsel who has appeared before the tribunal on one side. And I think I have a quote here. And so that's just a quote from the decision. And you'll see the issue for the court really is that justice cannot appear to have been done when the real decision maker, reasons writer, name does not appear on the bottom of the decision. And so it's not good enough that the tribunal members just signed off on the decision. They really had to have had a hand in the writing of it, and the prosecutor should have had no hand in writing it. And in this case, what was interesting was, in an effort to kind of defend their practice, the commission had that prosecutor swear an affidavit where he set out his role in that, and it tried to explain that really he took no part in the decision itself, that the tribunal had told him what the decision was, and all he really did was reduce it to writing. And the Court of Appeal rejected that, saying that's not good enough. A party who's been, who will be affected by this decision has a right to know the reasons of the decision maker, and shouldn't have to piece it together by reading the decision and the affidavit of the actual author. There's another case that raises this as kind of a side issue, and I know this was a case that Will was familiar with.
Yeah, this is a sort of a famous case. This is kind of a famous case, the Highway Transport Commission case, where it emerged that the chair, who was one of those great old-time political appointments, followed this practice with great regularity. That in this case, UPS was looking for a license, was opposed by Canadian Pacific Express. UPS won, and the chair of the tribunal said, "Look, phoned up and said, look, good news, bad news. Good news is you won. Bad news is you got to write the reasons." And it's kind of unclear how this came to light, but the court was very damning of this. But it's easy to kind of slip into this, that when I was a young lawyer, in the district court in Toronto at least, this appeared to be something that some judges would do. They were more open about it. They would say, all right, I'm going to agree that these 8 questions should be answered, or whatever the motion was, and they'd say, would you mind getting a draft of reasons over to me? And so you'd write, Mr. McDowell, with his usual brilliance, has persuaded me that blah, blah, blah. But it was denounced, I guess, by the Court of Appeal on a couple of decisions from the district court, and seemed to disappear when the courts merged. Now, get the right slide here.
Oh, sorry, do you want me to
The next one.
No, the next one's staff.
Go ahead.
Okay, all right. So the next kind of role counsel can take is as staff counsel or legal advisor. So someone who's in-house with the tribunal, and that was something that Julie was going to be able to speak to very specifically as in her role as. I think she's the director of legal services in the tribunal in Quebec, but we'll do our best to speak on it as well. I think generally the the level of unseemliness to the role that a staff lawyer might take is much lower than in the situation that we were just talking about, where a lawyer has appeared in front of the tribunal and then is asked to take part in the decision or the deliberation.